Good afternoon, everyone. My name is Dr. Ramakrishna Hegde, working as an associate professor in the Department of Computer Science and Engineering at Vidyavartaka College of Engineering, Mysuru. On behalf of Vidyavartaka College of Engineering, I would like to welcome today's resource person, Mr. Karthik Puttaya. He's basically a co-founder and CEO of Inventory. He's with us today. Welcome you, sir, to today's webinar. And also, I would like to welcome all the participants for today's webinar. Before proceeding this particular webinar, we know that most of us, including the students and faculties, we come up with a lot of innovative ideas, and most of the time we end up with converting into kind of a papers and trying to publish in some of the journals, reputed journals. But the next step supposed to be a patenting where we all facing a lot of problem. There's a lot of challenges lies, because this is where we are struggling to get patent to our creative ideas, maybe innovative ideas. For that, I requested Mr. Karthik today to guide us how to go about for the patenting and everything. He accepted. Thank you for accepting our invitation today, sir. Before proceeding, I would like to introduce Mr. Karthik today. Mr. Karthik is a co-founder and CEO of Inventory. His decade-long patent practice has made him an expert in securing patents, advising on patent portfolio management, portfolio development, and mitigating IPR-related risks. His counsel is especially sought after in hearing before the Indian patent experts due to his impressive track. Due to his impressive track record of success there. Mr. Karthik is a popular speaker at IP conferences and often delivers instructive talks on topics ranging from IP policies to the practical aspects of patent practices in India. Apart from delivering talks at conferences and seminars in India, he has enjoyed delivering speeches at conferences in the US, Japan, and South Korea as well. So this is the brief introduction of today's resource person, Mr. Karthik. I think now I would like to hand over the session to Mr. Karthik. He's going to guide us how to go about the patenting. So over to you, sir, Mr. Karthik.
All right. So thanks a lot for the introduction. So without further ado, let me begin my presentation today. Now, before we get into the most important aspects of IP, which probably is patent, which most of you are interested in knowing, we will just get an insight into various forms of intellectual property. Now, to understand what intellectual property is, I think we need to take a step back and try and understand the different types of properties itself. Now, when somebody talks about property, typically one can tend to think of what is called as tangible property. As an example here, we have a car, which is a tangible property, a house is a tangible property, or a plot of land is a tangible property. So which means to say that a property that one can physically feel is called as a tangible property. So the way ownership transfers in terms of tangible property is when that physical manifestation is handed over to another entity. That is how the ownership kind of transfers, as opposed to intangible property. So as the name kind of suggests, this is the kind of property where it does not have a physical manifestation, so to say, or the physical manifestation itself is not the property. As an example, let's take a Harry Potter novel. Now let's consider a situation wherein another person makes copies of a Harry Potter novel and starts selling those copies. The publisher of Harry Potter novel will have a problem with that. That person will have a problem not because somebody stole the novels that were published by that authorized publisher. Instead, they'll have a problem because somebody in fact just made a copy of this particular novel and selling it. So intuitively, we kind of know that even making copies of something and selling those copies itself is wrong. Let's take another example. Here I have a logo of a popular brand, car brand, Mercedes. Let's consider a situation wherein a competitor or somebody who does not even have a standing in the field starts using this logo on the cars that they manufacture. The moment somebody sees that, one might think that this car is probably somehow associated with Mercedes Benz. And in a situation like that, Mercedes Benz will have a problem. Not because somebody actually physically stole a Mercedes logo that was produced by Mercedes. Instead, they will have a problem because somebody used their logo, right? So it is some kind of an intellectual asset that is being stolen by a third party without any authorization. So likewise, I have another image here of an engine, right? Now let's consider a situation wherein somebody does not really steal the engine itself that might be manufactured by, let's say, Mercedes. Instead, they copy the technology that Mercedes-Benz had used in this particular engine. Even in a scenario like this, we intuitively know that even though the physical manifestation itself is not being stolen, what is being stolen in each of these instances are of some value, right? And each of these instances, the property being stolen is somehow created by human intellect, and that is what is called as intellectual property. Now, in each of these examples that I gave, you would probably intuitively know that each of these examples kind of differ from one another in terms of the value it adds to its owners itself. Now let's try to understand that using some more examples. Now let's consider a company such as let's say Mercedes, and let's think of the different types of intellectual property that a company like this might own. In the first example, I have an engine which this company might have developed. So they might have made certain improvements in the technology itself, right? And some of that technology needs to be protected. So at one end, we talk about intellectual property in terms of improvements made in the field of science and technology. And that could be termed as one kind of intellectual property. Now let's consider another scenario. This company manufactures cars, and the way their product looks is it's kind of aesthetically appealing. Now let's consider a scenario wherein somebody starts manufacturing cars that exactly look the way a Mercedes car looks, right? So in this case, it is the aesthetics of the product which is being stolen by an unauthorized third party, right? So this is another type of property which is the aesthetics of a product itself, or the way a certain product kind of appeals to the eye, right? So this is while we spoke about development in the field of science and technology in the first example with respect to the engine. In the second example, we spoke about how a product looks, the aesthetics of a product as another example, which is fairly different from each other. Now let's take the third example of a logo. Now, the moment somebody uses that logo on a product, you can kind of associate that, yes, by this product is probably manufactured by Mercedes just by looking at the logo itself. So you have another type of property which, by applying it on a product or a service, you kind of associate that product or the service with a certain company. So that is another distinct type of intellectual property. Now we have another example here. In this case, it is a user manual, right? So the company has put together sort of information that an owner can use while they are operating their vehicle, right? So this is an expression of thoughts in the form of literature, right? Now each of these examples kind of indicate intellectual property, and they are distinct in terms of what they're supposed to serve as their end objectives. So which means to say that to protect each of these different types of intellectual property, we have to somehow have laws that are kind of tailored to the kind of intellectual property that it is. Now let's look at the different types of intellectual property. Now when it comes to technology, if it is some improvement made in science and technology, then what can protect something of that nature is called as patents. So what we need to understand is that if we are talking about protecting certain improvements that we have made in the field of science and technology, then the apt way of protecting that is through patents. Moving on. Now, let's say we have come up with a certain aesthetic design of a product, and we don't want to necessarily protect the function, but we just want to protect the way a product looks, because sometimes the look of a product gives a lot of competitive advantage. Even though the technology might be very similar, just by the way a product looks, just by the way a product kind of appeals to the eye, has a lot of value. And when we want to protect the aesthetics of a product and aesthetics of an industrially developed produced product, then the way to protect that is by what is called as industrial design, or also referred to as design patent in the US. Now, moving on, the brands itself, right? So here we are looking at a logo, or it could be a word. For example, Mercedes-Benz itself is a word. That is also a trademark. So a trademark is something that can associate a product or a process to its origin, which could be a company. So this logo here, to whatever it is applied to, a person looking at that particular product will associate that product with the Mercedes company, right? So something when we are dealing with something of that nature, then what protects it is called as a trademark. So likewise, we have copyrights, expression of thoughts. It could be expression in terms of, let's say, novels. It could be expression in terms of literature. It could be as simple as a blog, or it could be something like a source code, which are all protected under copyrights, right? So these are broadly the different types of intellectual property. So there are many more types of intellectual property, but generally speaking, these are the four common types of intellectual property we kind of come across in our daily lives. Now, having understood what are the different types of intellectual property that one might be dealing with, and what are the appropriate types of protection for each of the different types of intellectual property, now let's move on and try to figure out what each type of this intellectual property protection has to offer. In terms of whether registration is mandatory to actually claim it is your intellectual property, how long is that intellectual property valid, and in terms of geography, to what extent it is spread out. Now let's start with registration itself. So when it comes to patents, as you can recollect, is the type of intellectual property protection that is offered for improvements made in the field of science and technology. So when it comes to patents, registration is mandatory, right? So let's consider a situation wherein you have come up with some kind of an invention. So typically when I say invention, there is a lot of misconception that it has to be something breakthrough. But as such, if you were to look at the field of patents, it's generally incremental improvements that is made on what is known as state of the art, right? And those incremental improvements that are made can be protected as patents. But just because you made that incremental improvement does not mean that you would be entitled for a patent, or you are entitled to have monopoly over that particular technology. So unless you actually apply for a patent and get a patent granted, you cannot establish monopoly or the invention that you might have created, irrespective of how good that invention is. So in terms of, when it comes to science and technology and you want to protect inventions, it is through patents, and registration of a patent is mandatory. And if you have not registered a patent, then that invention is free to be copied by anybody else. Moving on, industrial design. So when it comes to industrial design, again, registration is mandatory. So as you can recollect previously, I just mentioned that if you want to protect an aesthetics of a product, of an industrially produced product, then you can do so using design registration, industrial design registration. So again, the key point to take away here is that this registration is mandatory. So irrespective of how unique a certain aesthetic design could be or how appealing an aesthetic design could be, unless you register that design, you cannot really, very broadly speaking, you cannot generally stop others from, uh, using a similar design. Now, moving on to trademarks. So, unlike patents and industrial design, to establish that something is your trademark and stop others from using your trademark or your brand name or your logo, you actually do not require any form of registration. Right? So trademark, even without registration, you can establish that a certain logo or a certain brand name is your trademark, and you can still stop others from using something similar in a similar line of business, even though you don't have a trademark registered. Having said that, even although trademark registration is not mandatory to enforce your rights or a certain trademark, registration is highly recommended for several reasons. It is easier for you to enforce your rights if you have a registered trademark as opposed to an unregistered trademark. Moving on to copyright. Again, just like trademarks, copyright registration is not mandatory. However, if you register a copyright, it is much more easier to enforce your copyright. So that way, in terms of trademark and copyright, registration is not mandatory, although it is advisable. However, in terms of patents and designs, registration is mandatory. Now, from moving on from the registration aspects, we will talk about jurisdiction. By jurisdiction, what I mean is that if you have any one of these registrations, any one of these intellectual property protections, to what extent is it protected in terms of the geographical reach itself? Now, let's start off with patents. Now, patents are jurisdiction specific. We will certainly talk about patents in much more detail, but just to giving you a gist here, in terms of patents, patents are jurisdiction specific, which means to say that if you have a patent granted in, let's say, India, and you don't have a patent granted, let's say, in US, then somebody can actually go ahead and use your invention in the US, but you can only stop others from using your invention only in India. So it is jurisdiction specific. In other words, you will have to apply for patents in each and every jurisdiction where you wish to protect your invention. Now, moving on to design. Just like patents, industrial design registration is also jurisdiction specific. Right? Now, let's move on to trademark. In terms of trademarks, I've said that jurisdiction may not, the protection may not be jurisdiction limited, or in some cases it might be limited to a jurisdiction. Now let's look at it from two aspects. Now, when it comes to trademark, as I mentioned earlier, we could have a scenario wherein the registration is made. So in terms of the registration itself, if you want to register a trademark, if you were to register it in India, then that registration is valid only in India. So if you want to register your trademarks in different countries, you will have to apply for trademark registration in each of those countries. Now let's talk about an unregistered trademark. Now when it comes to trademark, now let's suppose you are using your trademark or you're in business only in India, in which case there is a possibility that somebody can go ahead and use your trademark in, let's say, in the US, as long as you have not really done any trade in the US. So in this scenario, I would say that trademarks, of course, is jurisdiction specific. In some cases, there could be scenarios like, for example, Mercedes-Benz, wherein they have their cars selling in multiple jurisdictions. So even though, as an example, they may not have registered this logo as a trademark, they can still enforce their rights in all of those different jurisdictions. So in some cases, certain logos have what are called as cross-border reputation. Examples of such trademarks are well-known marks, As an example, Mercedes, Nike, Adidas, McDonald's, KFC, so on and so forth have cross-border reputation, and they might qualify as well-known marks. And as a result of being a well-known mark, consider a hypothetical situation wherein, let's say, a McDonald was there all around the world, but not in India. But even then, the Indian consumer might still be aware of McDonald's, right? In which case, that protection might extend even in India, even though they are not trading in India, right? So these are the various scenarios in which in some cases it becomes jurisdiction limited, and then in some scenarios it does not become jurisdiction limited. Now, moving on to copyright, typically it is not jurisdiction limited. So which means to say that even in a scenario where you don't have anything registered, you don't have a registered copyright. Let's say you publish a novel here, and tomorrow somebody starts copying and selling your novel in the US. Even though you don't have anything registered in the US, you can, neither in India, let's say, you can still go ahead and stop that person from violating your copyrights. So that is about jurisdiction of different forms of intellectual property. Now, moving on to the duration of protection. Now, patent protection is for a limited duration of time. So that duration is 20 years. So the rights that you get when you get a patent granted, and those rights will exist for a period of 20 years. And beyond that, those rights would not be enforceable. Now, moving on to industrial design. The industrial design rights are enforceable for a period of typically 10 years, but you can extend it by another 5 years in most countries. So that is so from that perspective, I would say it is a maximum of 15 years. In terms of trademark, the protection that you get for a trademark, it is not limited by any duration. As long as you are using a certain brand name in your trade, it is your trademark, and you can enforce the rights that comes with something being your trademark. So from that perspective, you might end up owning a trademark for an infinite amount of time, as long as you continue doing trade using that particular brand name or a logo or trademark itself. Now, moving on to copyrights. Yes, again, copyright it is limited to a certain duration of time, although it is that duration is considerably lengthy as compared to, let's say, a trademark or industrial design. And the duration of copyright varies from by the nature of what is the subject of that copyright itself. For example, if you're talking about a novel, then the duration of protection that one gets is the life of the author plus 60 years. So that protection could vary from one country to another. So let's consider, for the sake of this discussion, that it is life of the author plus 60 years, which means to say that that copyright protection will be valid till the author passes away, plus 60 years beyond the date of death of that particular author, right? So it is a considerable amount of time. Now, having dealt with the different types of intellectual properties and the different types of intellectual property protection, and some nuances in terms of registration, jurisdiction, and duration, we will now move on to patents, right? Now, when we talk about patents, we will now go into much more details about patents. Now, to get a patent granted, there are various requirements that need to be met. Broadly, there are 5 requirements that need to be met, and we will talk about each of these requirements. So, for something to be patented, it can either be a product or it can be a process, right? But this product or process has to be related to a field of science or technology. So I emphasize on science and technology here. The reason being, now consider a scenario wherein somebody comes up with a business process. It could be a very innovative business process. As an example, let's consider multi-level marketing, right? Wherein you have a chain of people that is formed, and then there is incentive that is distributed across that hierarchy that is formed in the multi-level marketing. For a minute, let's assume that this scheme or a business scheme was brought to us for the first time. So no matter how innovative that business scheme is, or no matter how innovative that business process is, it cannot be patented. For something to be patented, it has to be an improvement made in the field of science and technology. And that improvement could be in terms of a product or in terms of a process, right? So as a subject matter, any product or process that relates to the field of science and technology can be patented as long as it also meets the other requirements of patentability. Now let's move on to the other requirements of patentability. We will collectively deal with the next two requirements, the novelty and then non-obviousness. Now, what is novelty? Novelty simply means that the invention that you have, be it a product or a process, let's simply call it an invention. Now, the invention that you have, there should be something unique about it compared to what is already there in public domain across the world. The second thing is non-obviousness. So the invention that you have, there could be something novel about what you might have come up with, considering what is there in public domain across the world. But that novel aspect might be very obvious, right? Now there are two things. What is called as obviousness, which is a very subjective matter. I will discuss that with an example. Now, the second aspect is, I said that it has to be novel considering what is there in public domain across the world. All right. So, what is there in public domain across the world could be collectively called as prior art. In the field of patents, that information is typically referred to as prior art. So, what constitutes prior art? So, prior art could be, let's say, patent applications filed. Irrespective of where it is filed, it could be filed in India, it could be filed in US, it could be filed in China, wherever. It could be in terms of non-patent literature. For example, you have publications. So you have so many journals in which people keep publishing their findings. So that typically is referred to as non-patent literature. So it could be patent literature, irrespective of where we find it. It could be non-patent literature, irrespective of where it is was published. It could be products or processes that have fallen into public domain, which means to say that products that are publicly being sold in whichever country. So likewise, processes which are publicly known in whichever country are all part of prior art. So in view of prior art, your invention needs to be novel and it should be non-obvious. Now, novelty is very straightforward. Now, to determine something is novel or not, what is done is that you take your invention and you compare it with a single prior art document, which means to say that, let's say we have found 5 literature, 5 patent publications, which we think are relevant to our invention. Now, to determine novelty, what we do is we do a one-on-one comparison. That is, we compare the invention with each of these relevant documents individually, and as long as with respect to each of the document there is at least some aspect that is different from that individual document itself, then it is termed to be novel. So as long as when we do a one-to-one comparison, and in each of those one-to-one comparison we figure out that there is at least some aspect that is different with respect to each one of those prior art documents, then we say that there is novelty. However, when it comes to obviousness, all of these prior art documents are considered as a whole, right? So now we are now contemplating a situation wherein it is not a one-to-one comparison between your invention and each of the prior art references. Instead, it is a comparison between your invention and the knowledge pool that all of these 5 prior art references bring together. Now, when we do this comparison, now the question is, in view of this knowledge pool that is established by these 5 prior art references, what we have come up with, is it obvious to a person who kind of works in that particular field? Again, it is a very subjective matter as to whether something is obvious or not, and it is typically in a patenting process, this is the requirement that is highly debated, and it goes either ways. The patent office might be eventually convinced that it is not obvious, and in some cases the patent office would remain adamant that it is obvious. And because of the subjective nature of this particular requirement, it is very difficult in some cases to say whether it will be struck down in this particular requirement or not. Now moving on to the fourth requirement, which is industrial applicability. Now the requirement is that whatever invention that you have come up with, it should be capable of being made or used in the industry. Now in most invention, this requirement is typically, straightforward, it will be met. But let me give you an example of where one would reject a patent, an invention based on this particular requirement. Now let's consider a time travel machine. Let's assume that we're talking about a time travel machine which is not even there, right? We don't even know whether somebody would be able to come up with a time travel machine. Now let's say I file or I come up with an invention, or I claim to have an invention, and that invention, let's say, is the steering wheel, and I say that this steering wheel is going to be used in a time travel machine and I want a patent over it, right? Now this steering wheel cannot really be used in any industry, because the application of this particular invention of yours, the field of application itself does not exist, right? When such is the case, there is a good enough chance that your invention, or what you claim is an invention, would be struck down as not to be meeting this particular requirement. Then the last requirement is called as enablement, or in other words, your invention need to be enabled. Now one thing that we need to keep in mind is that it is possible that you may not really have come up with the product to the fullest extent. In other words, you may not really have a prototype of the product itself, or you may not really even have a prototype of a process, right? Now the question is, even without a prototype, or let's say even you don't even have a 3D model of your invention, right? Even without that, can you go ahead and apply for a patent? The simple answer is you can go ahead and apply for a patent even though you don't have a prototype, right? But as long as you are able to provide sufficient information in your patent document to enable a person who has ordinary skill in that particular field to be able to make that particular product or use that particular process without too much of experimentation required. So as long as you have sufficient information that we can furnish in a patent document that enables a person having ordinary skill in that particular field to practice your invention, then that information is said to be enabling information, and you can and this particular requirement of patent eligibility would be met, right? So although you may not really have a prototype, you need to have sufficient enabling information that we need to furnish in a patent document to be applying for a patent. Another important aspect that I want to mention here is that when it comes to patents, you need to be applying for a patent before you actually make your invention public. So consider a scenario wherein you have come up with an invention, and now you're contemplating whether you want to publish it in a journal or should you go ahead and apply for a patent, right? So if you were to publish it in the journal first and then contemplating on applying for a patent, then in most jurisdiction you will not be able to apply for a patent. Or even if you were to apply for a patent, ideally it should be rejected because you made your invention public in the form of, in this example, publication in a journal before you applied for a patent, right? So you have to make sure that you don't put your invention in public domain before you apply for a patent. So in other words, if you have the intention of applying for a patent, then you need to apply for a patent first, and only thereafter you can go and put your invention in public domain. Now, putting an invention in public domain could be in various forms. As one example, you publish your invention in a journal. Another example, you come up with a product and then you start selling your product, or you start offering your product for sale, right? So that is another example of how one ends up putting the invention in public domain. right? So it is extremely important to note that a patent application needs to be filed before you put your invention in public domain. Having said that, this requirement of applying for a patent first is there in several jurisdictions, India being one of those jurisdictions. But there are certain jurisdictions wherein you do get a certain leeway, so to say, right? For example, in US, you have a 1 year leeway, which means to say that you within 1 year of putting your invention in public domain, which could be, let's say, in the form of publishing it in a journal, within 1 year of doing that, you need to be applying for a patent. Beyond that 1 year period, ideally, even if you were to apply for a patent, it should be rejected by the patent office by citing that you had published it in a journal much before and you had not applied for a patent within that short duration. So to be on the safer side, although some jurisdictions give you that 1 year grace period, to be on the safer side, it is always beneficial to go ahead and apply for a patent first and then think of putting your invention in public domain, especially when you are contemplating some product or process you're contemplating on applying for a patent. Right? Now, having spoken about different patentability criteria, we will now move on to a few other key considerations one need to keep in mind. Key consideration one, the jurisdiction and time span. As I mentioned earlier, patents rights are jurisdiction specific, right? So which means to say that if you apply for a patent in India and if you get a patent granted in India, then you will have monopolistic rights over that particular invention only in India. So in other words, you will have to apply for patents in each and every country where you want to establish monopoly over your invention. Now, many a times, when we say that patent rights are jurisdiction specific, a common question that comes across is that, one might come up and say, look, there is a product that is there in the US, or let's say even, there is a patent application filed in the US, but they have not really bothered to file it in India, or a product is being sold in the US, but they are not really bothered to sell it in India. Now, can I go ahead and apply for a patent? Since you say that it's anyway jurisdiction specific, which means to say that my rights are only specific to India. So why shouldn't the patent office consider only that information that is there within the Indian jurisdiction? Now, to answer that question, patent system does not work that way. Although the rights that you get granted when you get a patent granted is jurisdiction specific, to ascertain whether a patent should be granted or not, be it any patent office, that patent office, to ascertain whether a patent should be granted or not in that particular jurisdiction, has to first ascertain whether what you are trying to protect is an invention or not. And the definition of an invention is that it has to be novel and non-obvious, considering what is there in public domain across the world. Now, so which means to say that although the patent is jurisdiction specific, the rights are jurisdiction specific, it still has to be an invention, which means that it has to be unique considering whatever is there across the world, right? So it is very important to make that distinction. Now, in terms of the time span itself, as I mentioned earlier, patent rights last for a period of 20 years, and beyond that, the invention falls in public domain. What it means is that beyond 20 years, anybody is free to go ahead and copy that invention without being worried about the patent that actually existed for the last 20 years. Now, moving on, set of rights. Now, let's talk about set of rights. Right. So, when you get a patent granted, you get a set of rights. Now, those set of rights relate to making, using, offering for sale, selling, or importing that particular product or process. Now, here I want to make a distinction in terms of what are the rights that we get in terms of patents. So, when you get a patent, you get the right to exclude others, as you can see in the bottom of my screen. with patents, you get the right to exclude others from doing any of these activities. And it is not the right to actually carry out these activities, right? So there is a distinction between these two. So let's try to understand this using an example. Now let's say there is a patent that was granted to somebody, and that granted patent relates to a refill of a pen, or let's say there is a patent on a refill, that is an old patent. Now let's say you actually came up with a body and a cap, and you can put that refill inside this body, and then the tip of the refill can be closed using this particular cap, right? So this is certainly some kind of an improvement, considering that what existed was this refill, which was, one could write, but it was very difficult to write using that refill, right? So you came up with an improvement over this, wherein you came up with the body, and then this refill, the old on which that patent was there, you could put that refill inside that body, and then protect that nib or the tip using a cap. So certainly there is an improvement, and you might get a patent granted because of the improvement that you have made over this old patent that existed. Now, if patents were to offer you the right to make, offer, sell, import, use your invention, what it would mean is that because you got a patent granted, you can freely start selling this pen without really bothering about this old patent that actually is now part of your invention, right? So as such, a patent really cannot grant you the rights to do these activities, because if patents had granted you the rights to do all these activities, then the guy who had the earlier patent, his patent would would lose all its worth. So instead, to address this situation, the way the rights are given are in terms of negative rights, which means to say that it gives you the rights to exclude others from doing these activities. It does not give you the right to do all these activities. So what it means is that if now a third person were to actually manufacture a pen on which you have this new patent, then you can stop that third person from manufacturing this particular pen. But if you were to manufacture this pen, you might still have to take a license from the owner of this old patent. So that way, the earlier patents still have their worth, and that is there because of the set of negative rights that are given when a patent is granted. And those negative rights are the right to stop others from making, using, selling, offering for sale, or importing the patented invention, right? So those are the set of rights. Now let's move on to ownership. Now, when somebody applies for a patent, there are two important aspects in terms of ownership. Those important aspects are who are the inventors and who is the owner of the patent. Now, the inventors are always individuals, natural persons, human beings. It could be any number of human beings, but it has to be a human being. An inventor cannot be a company, an inventor cannot be a college or an institute or a university. It has to be individuals, right? So inventors have to be individuals. Applicants or the owners can be individuals, or it can be a legal entity. A legal entity, as an example, could be a company, it could be a non-profit organization, it could be a university, it could be a government, it could be a government institute, so on and so forth. So the applicant could be individuals, or it could be legal entities, or it could be a combination of individuals and legal entities, right? Now, in terms of the ownership of the patent itself, the rights that you get, all the commercial benefits that you get out of the patent always lies with the owners and not the inventors, right? So it is possible that the inventors are themselves the applicants or the owners as well, in which case they hold all the rights, commercial rights as well. But consider a scenario in a company wherein the employees become the inventors, whereas the owner or the applicant for a patent is the company itself, right? So which means to say that all the commercial rights over that particular invention or over that particular patent lies with the company, while acknowledging that, okay, these were the individuals who actually came up with this invention, right? So so over a period of 20 years, which is the life of a patent, the names of inventors will not change. But however, the ownership can keep changing, right? So a company can sell their patent to another company, so on and so forth. So the inventors remain the same, but ownership can change. So when you're applying for a patent, one needs to realize the rights of an inventor, which is more or less just an acknowledgement that these were the individuals, whereas it is the applicant who holds all the commercial rights. So this understanding is very important when deciding who the applicant of the patent application is going to be, right? Now consider a scenario wherein the owners or the applicant of a patent, if it is just one person, then the whole right is with that one person. But let's say there are two or more entities involved, right? Two or more applicants are collectively applying for a patent. When that is the case, each of the applicant will have what is called as an equal and undivided rights. So it's as if each one of them is owning the patent, and they have all the rights that are there in the patent without actually making a division in terms of what rights are between those entities who apply for a patent, unless there is an external agreement between those applicants as to how that ownership or how those rights need to be governed, right? So that is the case in terms of when you have multiple applicants for a patent application. Now let's move on into the patenting process itself. Now when it comes to patenting process, okay, so when it comes to patenting process, so this is the timeline. First, we apply for a patent. Now, when it comes to applying for a patent, the first application can be what is called as a provisional application, or it could be a non-provisional, or what is also referred to a complete application. A provisional application can be typically filed when, let's say, you don't have enough, resources in terms of money to invest in a non-provisional application. You might consider filing a provisional application. Or it could be a scenario wherein there are different legs of research and you want to kind of establish priority over each leg of research, in which case you might file multiple provisional applications and combine all of that and file a complete application. So in other words, the starting application could be a provisional application, or it can be a non-provisional or a complete application. However, what needs to be remembered is that if it is a provisional application, then within 12 months, you have to file a non-provisional or the complete application. So if you don't do that, your provisional application is abandoned. Now, irrespective of how you go about whether filing a provisional and then a non-provisional, or going about filing a non-provisional application straight away, now let's assume that you have filed a non-provisional application. This non-provisional application ordinarily will be published after 18 months. On the other hand, you can request that that your patent application, the non-provisional or the complete application, need to be published, in which case the patent office will publish that application within 1 year. Now, your application will go into the queue for examination. So you need to request for examination. Apart from filing of the application, you need to request for examination of the application itself. Now that request can be filed within 48 months from your initial filing date, the first filing of the application. From that date onwards, within 48 months, you have to file a request for application. And only after you file request for application, your application will be queued up for examination. So it is always advisable that you file a request for application along with the filing of your complete application, so that it is queued up immediately for examination. Now, during examination, the patent office also carries out searches using various online databases to see if there are any patent applications or journal publications published anywhere in the world that might be similar. In view of this examination, they might either grant a patent, or if they have any issues, they will issue an examination report, as I mentioned in box 107. So if you have issued an examination report, then you have 6 months time to convince the patent office that the patent should be granted. Now, during the course of this 6 months time, what can happen is that once you receive the first examination report, you will respond to it. You will file a written response to this examination report by providing arguments as to why a patent should be granted, both legal and technical arguments. We also try to highlight the differences between those earlier publications and what we are trying to protect, eventually trying to convince the patent office. Now, and then during those period of 6 months, we might as well engage with the patent examiner and speak with the patent examiner in person or via a video conference and try to get their perspective, share our perspective to eventually convince the patent office that a patent should be granted. So this to and fro between the patent office and the applicants is called as patent prosecution. So there is a 6 months period for this prosecution to happen, and eventually you get a patent granted or a patent is rejected by the patent office. So if a patent is rejected, of course, there are other bodies to which you can appeal against the decision of the patent office. That body is called as Intellectual Property Appellate Board, IPAB. It is similar to a court, high court, and you can appeal against the decision of the patent office. But typically within the patent office, this is the process and the timeline. Now, moving on to my last slide. As I mentioned earlier, patents are all jurisdiction specific, which means to say that if you want protection outside in multiple countries, then you will have to file for protection in each of those countries. And there are two approaches to it: the convention approach, and the second one is the PCT approach. In a convention approach, from the first filing of the patent application, now let's suppose you file the patent application in India, be it a provisional application or be it a complete application. Within 12 months of your first filing of a patent application, you have to file patent applications in whichever country you want protection, right? So you have a 12-month window within which you need to file patent applications in each of those countries where you want protection. Now, this approach, in this approach, you end up spending quite a bit of money if you are filing it in multiple countries within a short duration of 12 months. Now, to address this scenario, there is a second option. Now, the first option is typically advisable, wherein you just, let's say you file a patent application in India, and the other country that you wish to file for protection is, let's say, only the US, and you are not really bothered about filing it in multiple countries. So when you have just one or two countries wherein you want to file for patent, convention approach, the first approach is probably advisable. But in a scenario wherein you want to keep your options open for a longer period of time, or when you have a lot of countries you are still considering in applying for a patent, you might consider going for what is called as a PCT approach. It is a short for Patent Cooperation Treaty. It is also referred to as an international application. Now, the way it works is that from your first filing, assume it's an Indian application you filed, within a window of 12 months, you have to file this PCT application, also called as a international application. Now, if you have filed this international application within this 12-month window, you get about 30 months in some countries and 31 months in a few other countries to file patent applications in the individual countries, right? So this is more like a stopgap arrangement that you do by filing this international application within that 12-month period, so that you keep your option open for close to about 2.5 years to file patent applications in different countries. So this way, you are incurring an interim expense in the form of a PCT application, but the considerable expense of filing applications in different countries, you are pushing it to a later date, and within that later date, you might have a fair bit of idea about how well your technology might work. Is your technology going to be obsolete? Would there be a demand for your technology? So on and so forth. Would people be interested in your product? Is something that you would probably be able to figure out in roughly 2.5 years. Would be a good enough time, and then you can take a decision as to whether you would want to apply for a patent or not. One thing that I want to emphasize here is that although this PCT application is called as an international application does not result in an international patent that gives worldwide protection. So there is nothing in the whole world. There's no system that offers protection using a single application across the world. So at the end of the day, one will have to file patent protection in each of those jurisdictions, but one can take either of these approaches. But there are certain countries where it is formed like a group. For example, Europe, wherein you can file a single application, get a patent granted for the whole union. So likewise, there are certain unions in Africa and so on and so forth. But generally speaking, there is no single application that gives you worldwide protection. So this kind of brings me to the end of my presentation. And if somebody has any queries, I would be happy to answer.
Yes, sir. It's a wonderful information. I think this is what the information we required. We all waited for this kind of information, sir. Thank you very much for giving information. And there are a few questions now. One of the challenge we are facing is, especially for the computer science category, we come up with a lot of research with a lot of ideas in the term in the form of an algorithms and all. How do you go about for this case, sir?
Right. So when it comes to inventions that are there in the software field, there are specific requirements in terms of what kind of software inventions can be patented. So if you were to look at the law relating to patents itself, the law simply states that computer programs per se cannot be patented. So this is there in India, it is there in Europe, it is there in US, so on and so forth. But what we need to remember is that when it says computer programs, the source code itself cannot be patented. However, if the software invention is such that it actually addresses a technical problem and gives a technical solution to a technical problem, then it can be patented. Now let me explain this using an example. Now let's consider Skype as a product. Now Skype as a product, it enables you to have real-time wireless communication between, let's say, two remote devices. And to be able to do this, let's say there is encryption that is happening, decryption that is happening on the other end, then there is probably compression and decompression that is happening between two devices. There is probably certain algorithms or certain modules that are there that are optimizing the whole rich media that is being transmitted between these devices. So this is a pure technical solution for a technical problem, and something like this can be patented. Now compare this with another example that I give. Now let's earlier I spoke about multi-level marketing, right? So which is a business process. Now let's say I come up with a software platform which probably makes this business process more efficient in terms of if we have a hierarchy in this multi-level marketing, I have a software platform to input all of these different individuals into this platform, and the platform kind of decides what should be the incentive that should be passed on to each of the people that are there in this whole scheme, which is nothing but a business process that is expressed in the form of a computer platform. Now something like this will not be patented. Now the key question is the software invention that we have come up with, does it provide a technical solution, or is it a business process that is expressed in the form of a software? As long as it provides a technical solution to a technical problem, although that whole solution is run on, let's say, general purpose computers, general purpose computing machines, that invention can be patented. So the key question is it a technical solution to a technical problem, or is it a business? Is it a software expression of a business process?
Especially for the student category,
Yes.
actually, there is a very important question that since they are not earning anything, do they have a some special channel where the cost of patenting can be reduced for the student category?
Right. Now, if you were to look at Government of India, there is a scheme, especially for startups, not for students, wherein the whole patent office fee, the government fees, everything is getting reimbursed, right? So that is there in terms of assistance. Now, when it comes to students itself, we have something called as a patent facilitation center. So the patent office, there are many, let's say, a few patent agents who are enrolled as patent facilitators, right? Now, the way this functions is that essentially, the fee that is involved in drafting, searching, and filing, and then to and fro between the patent office, that fee is not paid by the individuals, right? So instead, what happens is that the patent facilitators that are there, right, they carry out this process, and the government is going to reimburse them for the services that they provide. However, I mean, in my view, there is a flaw in the system, because the rates that have been set by the government for providing the reimbursement rate that have been set by the government to provide these services is in my view not up to the standards of what average patent professional would typically charge for something of this nature, right? So that being the reason, sometimes one needs to kind of figure out what would happen if somebody were to take a service of that nature where the fee might be highly discounted. So one will have to, as a professional, one will have to figure out, yeah, this fee is highly discounted. How will I, kind of make up to it? Because once somebody says that okay, it is going to be free of cost, you will have thousands of people who are trying to apply for a patent because the government is anyway reimbursing. And if, as a patent professional, if I were to take up a project of that kind, and if I were to invest all my time into something of that nature, that becomes extremely difficult. So I think what kind of works is that if students are going to be applying for a patent, and if it is through a university who is going to be the applicant, and there's a university who is going to be incurring those expenses, then the university can impanel certain agencies or certain companies to take up that work. Now, when a university approaches, let's say, a company and or a firm like us, typically what happens is that because of the volumes that one could expect, one tends to offer a discounted fee at a much good quality, because we are now dealing with a large entity such as a university wherein we see a constant stream of work. So be it a university being an applicant or be it their students, one might end up passing on those benefits even to the students. So that way one would not compromise on the quality. At the same time, one would probably be more I would say in terms of money, they would be more efficient.
Yeah. Thank you, sir. Radhika, madam, are you there?
Yes, sir. There's
Yeah,
one
do we
more
have any
question from the participant side. Shall I take up that question, sir?
Please.
Participant asks, suppose you are granted a patent for a product. Is there any reason it could be withdrawn in future? If
Yes.
so, what would be the reason?
Right. Now, a patent, once it is granted, it can be invalidated at any period of time. So there is no guarantee that a patent, once granted, it cannot be invalid. So invalidation of patent happens a lot of times. Typically, let's say a patent gets granted and there is a third party doing an unauthorized use of that invention, and the patent owner tries to stop that other person, then the recourse that other person has is to somehow try and invalidate this patent. Now, there are various grounds under which a patent can be invalidated. As an example, as I mentioned earlier, the patent office carries out searches using various online databases to find out if there is something similar, and based on whatever they found, they examine they try to determine whether the invention is novel, non-obvious, and go ahead and grant a patent. So that it is always possible that the patent office actually missed out on a lot of references which might as well be relevant. So after a patent is granted, a third party who is interested in invalidating that patent can bring up documents that are more relevant, or might even use the same documents that are cited in the examination report in a certain other way, and emphasize that it should not have been granted. And yes, there are chances that because of these reasons and several other grounds, a patent can be invalidated even after a grant.
Yeah,
Thank you, Sarita. A lot of information you have shared with us. Madam, I think 3 o'clock already crossed.
Yes.
Can you wind up now? Karthik, is it okay? We can wind
Yes,
up now?
Yeah,
sure,
Maybe
sure.
Yeah, maybe we have some more questions. I'll communicate to you. Maybe later I'll get an answer from you. That we'll do it. Radhika, madam, please
Yes.
conclude the session.
Sure. Opportunity for me to express my gratitude for people who have been along with us in this conducting this webinar. First and foremost, I would like to express my sincere gratitude to the management of Vidyavardhaka College of Engineering. My sincere thanks to the principal of this institute and head of the Department of Computer Science and Engineering for giving us all the support in conducting this webinar. My heartfelt thanks to all the participants for being a part of this webinar and actively participating and acquiring all the knowledge given in this webinar. My heartfelt thanks to Mr. Karthik for accepting our invitation and being with us and giving such informative webinar. I hope everybody has benefited from this webinar and got lots of information. Thank you very much, sir, for being with us today. I also thank all the technical staff for assisting us in organizing this webinar. Thank you, everyone.
Good to be here. Thanks a lot.
Thank you, Karthik sir. Thank you very
Thank
much.
you.
Thank you.
Good day. Yeah, bye.
Thank you.